Hello and welcome. My name is Jason Capitan. I'm an advisor at Migrate, and this is the first of a three-part video series where we will discuss some of the most commonly made mistakes that partner visa applicants make. The idea is that by discussing these videos will hopefully help you with your own partner visa application should you decide to prepare and submit the application yourself. So before we get into it, I will just provide a very quick summary regarding why we think this video series is worth your time. First, we are an OISC-regulated immigration law firm. Second, we only offer partner visa services. And because of this, we've helped over 2,000 partners with their partner visa applications. Third, we have more than 470 lovely 5-star reviews. And fourth, as a firm, we understand how the Home Office operate. Our head of practice is Ed Lowe, who's worked in the Home Office for 20 plus years. And such insight is particularly valuable because there are two main sources of information that are relevant when it comes to partner visa applications. One, what the immigration rules say, and two, and perhaps more importantly, how Home Office caseworkers implement the requirements. Okay, so let's get into it. The first mistake that we have to discuss is relying too much on the online application form as the main source of information. Whatever you do, please do not complete and submit the online application form without first reading the Home Office guidance and relevant immigration rules. And the reason for this is because what actually matters is what the immigration rules say and how the Home Office caseworkers implement those rules, not what the online application form says. This cannot be stressed enough. There are three main deficiencies in the online application form. We'll discuss each of them in turn now. Firstly, the online application form often does not state all of the required documentation. So this is a screenshot of the online application form's document checklist for a recent client of ours. As you can see, it lists a total of 5 documents that are to be submitted. Well, our client, who was making an application from outside the UK as a fiancé, was relying on the sponsor's 6 months employment income to satisfy the financial requirement, and was relying on the sponsor's father's accommodation to satisfy the adequate accommodation requirement. Obviously, there's no mention of documentation relating to either the financial or accommodation requirement here, both of which really are mandatory. The other issue that can result from relying on the online application form is that, instead of not listing certain documents, is that it will list the documentation that is not applicable to the application in question. Here's another example. In this application, the sponsor was employed by a UK limited company which was solely owned by her father, and because the requirements change where the employer is a limited company which is solely owned by a family member, different documents are required in the immigration rules. If only these listed documents were provided, there would have been 3 possible outcomes. The first outcome is that the Home Office caseworker would overlook the fact that the employing company is owned by the sponsor's father and grant the application despite the immigration rules not being met. This is certainly possible, but in light of the significance of the application, we would generally not recommend that partners rely on Home Office caseworkers making a mistake. The second outcome is that the application will be refused. Whilst this may seem incredibly unfair as the online application form states documents that are not applicable, this outcome is certainly possible and is something that happens on a regular basis. Unfortunately, it's not a defence to state that the online application form requested the wrong documents. The Home Office's response will be that it's your responsibility to ensure that the immigration rules are met. And the third outcome is that the Home Office caseworker will send an email requesting that the documents required for companies which are solely owned by a family member are provided. A possible issue here, however, is that they normally give a 10 or 14-day deadline to email the documentation, when the required documentation here often takes several weeks to obtain. Now, if you're wondering why the sponsor being employed by a family-owned company is relevant, this is actually one of the commonly made mistakes that we will discuss in more detail in the next video. In short, the employer will be what is known as a specified limited company, which completely changes the requirements that apply. The final reason as to why you should not overly rely on the online application, but rather read the immigration rules and the Home Office guidance, is because the online application form does not discuss all of the relevant requirements. For partner visas, the relevant immigration rules can primarily be found in, firstly, Appendix FM under the following subheadings, and Appendix FMSE. However, since the immigration rules are not the most clearly phrased text that you will ever read, I think the 2 previous sources amount to approximately 25,000 words, we'd recommend that you start reading, firstly, the articles on our website, of which we have been told are exceptionally helpful. Secondly, the family policy document titled Family Life as a Partner or Parent, Private Life and Exceptional Circumstances, which provides a good overview of the requirements as they apply to partner visas. Thirdly, you should read Appendix FM 1.7, which discusses the most common refusal justification, the financial requirement. Fourthly, Appendix FM 1.7 Capital A discusses the accommodation requirement, as well as the financial requirement for those where the sponsor receives a permitted benefit. And if you're not sure what a permitted benefit is, we will discuss this in this video. And finally, you should also read the document English Language Requirement, Family Members under Part 8, Appendix FM, and Appendix Armed Forces. The second mistake that we will discuss relates to the definition of the words the date of application, which is something that you'll see mentioned throughout the Home Office guidance, immigration rules, and online application form. It's incredibly important that you know that the date of application is the date that the application is submitted by paying the Home Office fees. The Home Office fees are paid as part of the online application process, just after when you've answered all of the questions in the online application form. And contrary to what some partners would initially assume, it is not the date that the applicant attends the visa centre appointment. And on a slight side note, what is relevant about the date that the applicant attends the visa centre appointment is that it is this date in which the processing time will start. The date of application is incredibly important to know because 1. This is generally the relevant date that the requirements must be met. For example, cash savings and employment income are being used to satisfy the financial requirement. One day after the application is submitted, the cash savings figure drops to £0 and the employee loses their job. This does not affect the application in any way. The application will be assessed based on the date that the online application was submitted, the date of application. And secondly, it is important to fully understand the date of application because the documents that you submit must show that the requirements are met on this date. For example, the applicant submits their application by paying the Home Office fee on the online application form on the 1st of July 2021. If the relevant period for the financial documentation is the 6 months prior to the date of application, documents must therefore be provided covering the period 1st of January 2021 to 1st of July 2021. On the other hand, if the relevant period is 12 months prior to the date of application, documents should therefore be provided covering the period 1st of July 2020 to 1st of July 2021. Again, you will note that the date that the applicant attends the visa centre is irrelevant. The third commonly made mistake that we will discuss is getting housing reports done. Now, I know that some of you have read or have been told, perhaps even more than once by different sources, that you should include a housing report in your application to show that the accommodation is not overcrowded. And I admit I was initially taught to recommend the same in my first job in an immigration law firm. The idea was that, in light of the significance of the application as a whole, you want to err on the side of caution. However, since my colleague, Edlo, joined us and brought a wealth of information as to how Home Office caseworkers in practice process cases, this is not something that we generally recommend. And this is because these are not generally expected by Home Office caseworkers and are in fact rarely submitted. Furthermore, in the thousands of partner visa applications that we've been involved with, not once has an application been refused because a housing report was not submitted. In the vast majority of cases, getting a housing report done is a complete waste of money. With this being said, if there is a rather unusual reason that could raise into the question of the adequacy of the accommodation, such as relying on a mobile home, it is in these very limited circumstances that we would recommend getting one done. The fourth mistake that we will discuss is applicants relying on the wrong English language test. Firstly, you should know that there is a list of Home Office approved tests. Currently, this list includes IELTS for UKVI, IELTS Life Skills, Language Cert International ESOL CELT, PTE Academic UKVI or PTE Home, Skills for English UKVI, and finally Trinity's ISE or GESE tests. We feel that it's important to stress that only the above tests will suffice. The second thing to note is that the Home Office approved English language test must be taken at a Home Office approved English language test centre. If you do not book the correct test, you will end up with a certificate that does not contain a UKVI number, such as in the example to the right. And this is unlike the certificate to the left, which was taken at a Home Office approved test centre. Here, as you can see, it states a UK VI number. The fifth common mistake that partners make is not realising that if the sponsor receives what is known as a permitted benefit, the financial requirement will be completely different. The first question is therefore, what are permitted benefits? This is the list of the permitted benefits. The most commonly relied on benefits here seem to be carer's allowance, disability living allowance, and personal independence payment. The first thing to note about permitted benefits is that where a sponsor receives a permitted benefit, whether that's on behalf of their child or not, a different financial standard applies. Firstly, where a permitted benefit is not received, the minimum income threshold applies, and this requires partners to evidence that they have a gross annual income of at least £18,600. I say at least here because this £18,600 figure increases when there are non-British or non-settled children who are also applying for a visa. A person is essentially non-settled here if they do not have indefinite leave to remain, otherwise known as ILR, or permanent residency under the EU settlement scheme or prior EU law. And also, since British children do not need to apply for a UK visa, they will not affect the £18,600 figure. On the other hand, where a permitted benefit is received, the adequate maintenance requirement applies. The adequate maintenance requirement requires much less income to satisfy the financial requirement. In short, the net income, which is the income after the deduction of income tax and national insurance contributions, minus the housing costs, i.e. what needs to be spent on accommodation, has to be greater or equal to the amount of income support an equivalent British family of that size can receive. And if you'd like more information about the adequate maintenance test calculation, feel free to read our adequate maintenance test article on our website. The second thing to note about permitted benefits is that when this is received, the rules that relate to documentation can vary. For example, on the left, you can see the immigration rules as they apply to non-adequate maintenance applications, i.e. minimum income threshold applications, as it discusses the letter from the employer. However, on the right, you can see the immigration rules as they apply to adequate maintenance applications in relation to the letter from the employer. Here, you can see that the immigration rules vary in that, unlike non-adequate maintenance applications, among other things, it requires the letter to state the annual salary after income tax and national insurance contributions have been paid. The last commonly made mistake in relation to partner visas that we'll discuss in this video relates to the 2 years cohabitation requirement. It should first be noted that the 2 years cohabitation requirement only applies to those applying as an unmarried partner. If you are applying as a married partner, civil partner, fiancé or proposed civil partner, cohabitation is only one of the many factors that the Home Office caseworker will consider when assessing the genuine and subsisting relationship requirement. Because of this, if you and your partner have not lived together, this is not something that's necessarily detrimental to your application. In light of this, if you're not considering applying as an unmarried partner, feel free to ignore the rest of this video. The immigration rules defines an unmarried partner as a person who's been living together with the applicant in a relationship akin to a marriage or civil partnership for at least 2 years prior to the date of application, unless a different meaning of partner applies elsewhere in this appendix. So, not once did the Home Office think to elaborate more on this, which is mind-boggling since this requirement unfortunately does result in refusals and is applied rather strictly. With this being said, we're more than happy to share some of my colleagues' insights regarding this from the perspective of those who've worked in the Home Office for 20 plus years. The unmarried partner visa definition has several aspects to it. We'll now discuss 3 aspects in particular. 1. The must have lived together for 2 years requirement. 2. The akin to a marriage or civil partnership requirement. And 3, we'll also discuss the options available to you if you realise that there is a substantial chance of the 2 years cohabitation requirement not being met. Okay, the must have lived together for 2 years requirement. This is one which unfortunately is rather strictly enforced. In other words, if you and your partner are applying as unmarried partners and have not cohabited for 2 years prior to submitting the online application, there unfortunately is a substantial risk of your application being refused. And because of this, where partners are unable to evidence that they've cohabited for 2 years or longer, we would rarely advise that an unmarried partner visa application is made. Rather, we will discuss the alternate options available. So this is not to say that if an applicant and sponsor have lived together for fewer than 2 years, that it will be impossible for an application to be granted. In fact, we've dealt with numerous applications where the cohabitation did take place for fewer than 2 years. But in such a case, you will essentially be betting on being assigned a rather empathetic Home Office caseworker who's willing to exercise their discretion in your favour. For those who will have not cohabited for 2 years when the online application is submitted, but yet still want to risk it, there are numerous factors that are relevant, but obviously the main consideration is how close the applicant and sponsor are to being able to evidence 2 years. And what I will say, however, is that if you're only able to evidence fewer than 1.5 years of cohabitation, the likelihood of being able to satisfy this requirement is unfortunately rather slim. Another thing to note about the must have lived together for 2 years requirement is that this period does not necessarily need to be continuous. For example, if you and your partner have lived together with each other for 1.5 years at one place, or apart for 4 months, and lived with each other for 1.5 years at another place, this is something that, on the face of it, should not be problematic. This is especially the case where there was a justifiable reason for the time spent apart, such as one or both partners having work commitments. Where there have been periods apart, these should be discussed in your letter of supports. The third thing to note is that the immigration rules does not require cohabitation on the date that you submit the application. For instance, it's sometimes the case that, due to the particular circumstances, we would recommend that the applicant leaves the UK and applies from their home country. This can be absolutely fine, even if the sponsor of the application remains in the UK. And if you are not going to be cohabiting when you submit the application, this is again something that we would recommend explaining in your letter of support. The last thing to stress is that there is a rather high documentary threshold when it comes to this requirement. In other words, not only must you and your partner have cohabited for 2 years or longer, but you must also be able to adequately evidence that you have. The documentation that you submit to show the cohabitation must carry a certain weight. A letter from a family or friend stating that you've cohabited will unlikely suffice alone. Unfortunately, obtaining adequate cohabitation documentation is something that can be problematic for some partners. For example, we recently spoke with a couple where the majority of the cohabitation took place in hostels and campsites. And not only would it be rather difficult to evidence cohabitation here, but also the Home Office generally expect to see much more formal documentation. Again, not all documents are to be given the same weight. The next aspect to the 2 years cohabitation requirement is that the cohabitation must have been akin to a marriage or civil partnership. For the majority of applications, this is not an aspect which requires careful attention. There are, however, certain groups of partners where this will be relevant. Now, this is an approach that is not referenced at all in any public Home Office guidance, but we know from Ed and Matt that where one partner is on a visitor visa or other short-term visa, depending on the application as a whole, some Home Office caseworkers may discount that period of cohabitation. Obviously, if partners have cohabited for 3 years and only 6 months of the cohabitation has been where one partner was on a UK visitor visa, that would not necessarily be problematic. On the other hand, where partners have mostly cohabited whilst one or both partners were on visit visas, this, depending on the particular facts, can be problematic. So, if you do intend to apply as unmarried partners, I hope that this has given you more confidence in your ability to satisfy the 2-year cohabitation requirement. However, if you're directly affected by one of the previously discussed requirements, you'll likely be wondering, well, what are our options if we do not currently meet the unmarried partner visa requirement? The first option, but by no means necessarily the best option, is to submit the unmarried partner visa application, despite knowing the risks of refusal. With this option, you will essentially be betting on being assigned a Home Office caseworker who would exercise their discretion favourably regarding the 2 years cohabitation requirement. Whilst there are some circumstances where this would be a reasonable approach, this is not something that we would generally recommend in light of the costs and time involved with submitting a refused application. The second option is to delay the application until you've cohabited for 2 years. This will involve cohabiting either overseas or in the UK. If you're wanting to make an application from inside the UK and the 2-year period will have passed prior to the applicant's current visa expiring, then that is straightforward, as you can simply wait until the 2-year period has passed and then submit the application. However, if you're wanting to make an application from inside the UK and the 2-year period will not have passed prior to the applicant's current visa expiring, in order to meet the 2 years cohabitation period with both of you staying in the UK, the applicant will need to extend their permission to be in the UK, and depending on the particular circumstances, this can be rather difficult. The third option is to marry or enter into a civil partnership and then apply as a married or civil partner. This would require you to marry or enter into a civil partnership prior to submitting the application. The benefit of this is that it removes the 2 years cohabitation requirement completely. Since cohabitation is only one of the many factors which may suggest a genuine relationship, according to the Home Office guidance, the fact that you and your partner will not be able to evidence 2 years cohabitation in the majority of cases becomes completely insignificant. And the last option, if you want to go down the partner visa route and are willing to marry or enter into a civil partnership, which is obviously not something that all partners are willing to do, is that you can consider applying as a fiancé or proposed civil partner. And just like those applying as a married or civil partner, not cohabiting for 2 years is not something that's necessarily detrimental to an application. And this option is more of an option for applicants who do not currently have any UK long-term visas, as unlike married and civil partner visa applications, fiancé and proposed civil partner visas can only be applied from outside the UK. And so that's it for this video. In the next video, we'll discuss more commonly made mistakes that you hopefully find helpful.